We begin with a historic ruling from the nation's highest court that deals a major blow to the White House's immigration agenda. The Supreme Court has upheld a broad interpretation of birthright citizenship, rejecting President Donald Trump's executive order that sought to deny citizenship to children born in the United States to parents who are in the country illegally or temporarily. In a decision issued Tuesday in a New Hampshire case, the justices relied on a long-settled understanding of the 14th Amendment adopted after the Civil War and federal laws to rule that anyone born in the country is a citizen with limited exceptions. The administration's restrictions had previously been blocked by multiple lower courts and never took effect. Joining us now to break down the Supreme Court's major decision today on birthright citizenship is Judge Andrew Arthur, a former immigration judge and resident fellow in law and policy at the Center for Immigration Studies. Judge Arthur, welcome back.
Thank you so much for having me today.
So a big day. The Supreme Court handed down the major decision involving President Trump's executive order on birthright citizenship. What did the court decide, and what impact will this have moving forward?
So the court struck down the president's executive order, which would have banned the children of those here unlawfully and what we call non-immigrants, temporary visitors to the United States, from attaining citizenship based on birth here. And so in doing that, it reaffirmed an 1898 case, Wong Kim Ark, in which the Supreme Court had ruled based upon English common law that the 14th Amendment citizenship clause, the one that conveys citizenship in this country, is to be read very expansively with only very narrow exceptions for children of diplomats or kids born in areas under foreign occupation. So this is a big loss for the administration, a big win for those who oppose what President Trump is trying to do on immigration.
Despite this ruling, what remains is that people are weaponizing this law. So what options, if any, remain for those who want to change U.S. citizenship policy in the wake of issues like birth tourism and, of course, bad actors looking to exploit this?
So yeah, and that's a great question, Veronica, because the main weaponization that we, talk about when we talk about birthright citizenship is what's called birth tourism. Individuals, women who travel to the United States exclusively to give birth here so that they can have a United States citizen child. I think one of the things that we're going to see is that the State Department is going to be cracking down on non-immigrant visas, temporary visas for people coming to the United States. And there will probably be an additional question on the questionnaire. Are you pregnant, or do you plan on becoming pregnant? I think that we'll also see those restrictions carry over to the ports of entry. So if a woman, shows up and she looks that she's, to be 39, 40 weeks pregnant, the inspector at the airport may take her aside, find out what her intentions are coming here, whether she plans on giving birth, whether she has the money to pay for the birth of a child in this country.
Judge Arthur, thanks so much for breaking it all down for us.
Thank you so much for having me today, Veronica.